Welcome back to the Law of Self-Defense Show. I am, of course, Attorney Andrew Branca for the Law of Self-Defense. Thank you so much. In today's show, we're going to conclude our reading of The Art of Cross-Examination with the last two substantive chapters from this fine book. This book was written by attorney Francis Wellman, an attorney out of New York City at the turn of the century, not the most recent turn of the century, the prior turn of the century. This book was originally written in 1903. The edition I'm holding in my hands, because the book was had many additions, many updates, more chapters added over time, over several decades. This version of the book was printed in 1948, so still quite old. It was a gift to me when I graduated law school. Because of the age of the book, written 120 years ago, the language comes across as fairly stilted sometimes by modern standards. Makes it a little awkward to read as an audible book, but nevertheless, we're making our best effort, and I trust you'll get value out of it. Now, today we're going to read the last two substantive chapters of the book, chapter 11 and chapter 12. Both of these are guest-authored chapters, not written by Francis Wellman, but chapter 11 on the dangers that confront a cross-examiner is written by Max Stower, and chapter 12, uses and abuses of cross-examination, is written by Emory Buckner. That actually only gets us to the halfway point of this book, but the chapter 12 is really the last substantive chapter of lessons. The remaining portions of the book are famous cross-examiners and their methods. It's a lot of the kind of Q&A that's difficult to read effectively in an audible book type format, and probably difficult for the listener or viewer to really follow. At least I found that to be the case when we've done that in bits and portions. So rather than read several hundred pages of Q&A, I'm going to wrap up our reading of The Art of Cross-Examination with that last substantive chapter 12. And I'm doing both 11 and 12 because 11 is relatively short and 12 is only a couple of pages long. So I thought it best to combine them into a single show. But before we jump into the conclusion of our reading of The Art of Cross-Examination, a quick word from our sponsor. If you've ever wondered what it would be like to have a lawyer-like understanding of the many high-profile trials and legal issues we cover, well, I've got exciting news. Our very own American Law courses offer a wide variety of law school-level courses, including the foundational courses all lawyers take in their first year of law school at a fraction of the cost and time of law school, and without the toxic political environment that so pervades law schools today. At American Law Courses, we simply teach traditional American law in the traditional American way to help Americans become the best informed, most capable citizens they can be. We have a broad curriculum of courses, including criminal law, criminal procedure, evidence, property, constitutional law, and more. All courses are taught on a semester basis, roughly one live-streamed class a week for 14 weeks, with an optional final exam for certification at the end. Every class is taught by a genuine legal expert in the respective subject, and because the classes are live streamed, there's plenty of opportunity for real-time interaction and Q&A with the professor. If you can't make a particular class for some reason, no worries. Every class is also made available as a recorded playback, and you have access to that recording for a full year. We've technically just ended the pre-registration period for the spring 2023 semester, which starts the second week of January. But for those of you accessing these readings of The Art of Cross-Examination, we've decided to extend that period for a few more days. This matters because during pre-registration, you can save 50% on any and all American law courses. That's a savings of over $1,000 a course. So if you'd like to learn more, now would be the time to do so. Learn more about our American Law courses, access the syllabus for each course, view interviews with our professors, and much more by simply pointing your browser to AmericanLawCourses.com today. All right, folks, we're back to conclude the reading of The Art of Cross-Examination by Francis Wellman, chapters 11 and chapters 12. We'll start first with chapter 11, The Dangers That Confront a Cross-Examiner, a guest chapter written by Max D. Stower. Cross-examination is usually regarded as the means by which adverse witnesses are discredited, and it is for that purpose that it is usually employed by the bar. The importance of it in that regard is self-evident. If through the instrumentality of the cross-examination the integrity of the witness is destroyed, even though it may be not with respect to the particular testimony given at the trial, if his general reputation for truth and veracity is shown to be bad by his own utterances, clearly the examiner has very greatly helped his case. In this effort, however, there are two lurking, if not great, dangers. One is to cross-examine when it is quite unnecessary, and the other to overdo the cross-examination. A recent experience will perhaps tend to illustrate the point. A defendant in a criminal case was charged with having bribed a government inspector. Witnesses were called to establish the good reputation for truth and veracity of the defendant. There was a time when such testimony was of real and substantial value. At the present time, particularly in the federal court, under the rules there in vogue, that character of testimony has become of very slight importance. In this particular case, a number of witnesses took the stand to testify that the defendant bore an excellent reputation for truth and veracity. In each instance, the prosecutor undertook to cross-examine the reputation witness. What I am endeavoring to demonstrate is the ill effect of cross-examining when it is really not necessary or of overdoing it. The judge had several times stated that the direct examination was limited to the inquiry as to whether or not the witness knew the reputation for truth and veracity of the defendant by the speech of the people in his vicinity, and if he indicated that he did, to state whether that reputation was good or bad. He made it quite obvious that he did not consider testimony of that kind very significant in a case where a man was charged with bribing a government official, and particularly where it was conceded that money had passed from the defendant to the official after the latter had made known to the United States Attorney that it had been proffered. An arrangement had been made so that the defendant should be caught in the act. Nevertheless, as has been stated, several witnesses were called to testify, and in each instance they were asked, and this particular witness had put to him, the question: when you came to know him and knew people who knew him, from the way that they have spoken of him, do you know what his reputation is in the community? Prosecution: I object to the question as immaterial. The court: isn't it in the same form you expressed with the previous witness by knowing the speech of those who know him? Defendant's counsel: yes, I think very frequently you gather what a man's reputation is by the way people talk. The court: there is a stereotyped form that you know well. Just ask him about it. You have asked that question many, many times. Question: by the speech of the people, have you come to know the reputation of the defendant for truth and veracity? Answer: I have. Now on cross-examination by the state prosecutor, question: Mr. Witness, you are not giving us hearsay statements of others. You are giving us your own opinion. Answer: I do. Prosecutor: I move to strike it out as incompetent. The court: strike it out. The witness: the opinion of others that I have heard. The court: let's us boil it down. You were asked by defendant's counsel if you know by the speech of those who knew him what his reputation was. You say you do. The witness: yes. The court: tell us in a few words what that reputation is, not what you thought, but what you have heard. The witness: I have heard that he is a very fine family man. He is a good father to his children. He is a good husband to his wife, that he lives in a very noble way in his neighborhood. The prosecutor: I object and move to strike out the answer. The court: it only has bearing on his reputation for veracity and honesty. What is his reputation for veracity and honesty? The witness: very good, first class. The court: that is all that is necessary. If there had not been a word of cross-examination, the usual humdrum of the witness being permitted to be asked one question on direct examination, to which the answer would be very good, excellent, or even the best, practically no attention would be given to the testimony, and nothing of importance would be elicited. Here, by reason of an attempted cross-examination, the witness was permitted to say that the defendant is a very fine family man. He is a good father to his children. He is a good husband to his wife, that he lives in a very noble way in his neighborhood. How much that testimony had to do with the disagreement of the jury in that particular case, nobody will ever know. But there may have been several men who reached the conclusion that if a man is a very fine family man, is a good father to his children, is a good husband to his wife, and does live in a very noble way in his neighborhood, it is difficult to believe that a person of that type would stoop to bribing a public official. At any rate, the testimony was made much more important and impressive after the cross-examination than could possibly have been at the conclusion of the direct. Instances of that kind, of course, can be multiplied. They occur with the utmost frequency, and it is important for a lawyer who prepares himself for the trial of causes to bear that in mind. Now, only in rare instances does the lawyer who is in the trial of a case give serious thought to the cross-examination before he is confronted with the necessity of proceeding with it. And particularly in few instances is it that the lawyer gives serious consideration to the law applicable to the particular situation with relation to which he is about to cross-examine. In the same case to which I previously referred, the inspector who it was claimed had been bribed by the defendant was under cross-examination. It is of the utmost importance to bear in mind that where a defendant is charged with bribery, if in fact the person bribed originates the suggestion and thus sows the seed so that the idea of bribery came to the defendant first through something that the government official said, by reason of which the defendant starts to plan the bribe, the defendant may not be convicted. Folks, we would call that entrapment today. The inspector was interrogated on cross-examination as follows. The witness. He, the defendant, said, "Can you wait a few days on the report until I can secure the names of the people who have licenses?" And I told him, "No, I can't wait." Question. You said you could not? Answer. I could not. Question. Was it then that you started to go to the elevator? Answer. At the time, he began explaining how important it was over and over again and how he was scared. He had mentioned over and over that he was afraid he was going to lose his license. And could I remain? It was about that time that I went to the elevator. Question. He asked you whether you could remain for a few days? Answer. Yes. Question. Did you give him a reason why you could not? Answer. Yes. What reason did you give him as to why you could not? Answer. I said I had to return to get back to my work. Question. Is that the only reason you gave him? Answer. Yes. Question. Nothing said about the expenses involved in your staying there? Answer. The only time that expenses were mentioned, he asked me where I was staying, and I said the Hotel New Yorker. He made a gesture with his hands like it was a pretty high-class hotel. Question. He made a gesture with his hands like it was a pretty high-class hotel? Do you really mean that? Answer. Yes. Question. You understood from his hand that he was gesturing or talking about the fact of the New Yorker being a high-priced hotel? Answer. At the time, I said that the Hotel New Yorker is rather expensive. That is the only time expenses were referred to, and after that, he never mentioned expenses in any way whatsoever. Question. You said that from the time you referred to the hotel being rather expensive, he never referred to expensive or expenses again? Answer. No. Question. Did you refer to expensive or expenses again? Answer. No. After that one utterance by you about expensive, that ended your reference to the expenses or expensive, is that right? Answer. That is correct. Question. When you went to the elevator, there was nothing said about expenses? Answer. I told you what was said about expenses. Question. I understood you. I just want to make sure. Was there or was there not anything said? Answer. The only mention of expenses was when he asked me where I was staying, and I said the Hotel New Yorker, and he made a gesture, and I said, yes, it is rather expensive. The court. Do you recall whether that was in the office or in the elevator? The witness. That was in the elevator. Juror number 12. Will you have him speak clearer, please? The court. A little louder. Question. This is cross-examination by the defense attorney of the government official who says he was bribed. Question. That having been at the elevator, was there anything said about money or expenses or expensive at any other time or at any other place while you were in the defendant's premises? Answer. Yes, sir. There was the... Answer. Yes, sir. That was the only time any mention was made of expenses or expensive. Question. Is it entirely clear that there was no suggestion by you or by him with respect to money, paying you anything or making good your expenses or anything of that sort? Answer. There was no statement whatsoever. Question. But you asked him to call you up. Answer. I did not ask him. He asked me, could he call me up? Question. And what did you say to that? Answer. I said, yes. Question. Did you fix a time when he should call you up? Answer. He asked me if he could call me at 6 o'clock. Question. You told him he could call you at 6 o'clock? Answer. Yes. Question. Did you intimate to him that you might stay over? Answer. No, sir. Only I told him when he asked me, could he call me at 6 o'clock? And I said he could. He took that as an indication to grab my hand and said, I will seal our secrecy with death. Question. Seal our secrecy with death? Answer. Yes, I know the word death was in there. I got a little chill at the time. Question. What? Answer. I know the word death was in there. Question. What did you add? Answer. When he mentioned death, I got a little chill up my spine. Question. Got a chill up your spine? Answer. Yes. Question. When he was coming up after you concluded your telephone message, did you then understand that he was bringing the money? Answer. No, sir. Question. Had it occurred to you that he might bring money? Answer. Yes, it did, because he said he was going to make it worth my while. Question. Did you ask him how? Answer. No, I strictly stayed away from asking him anything about that. Question. When he took out the money, were you surprised? Answer. No, sir, I was not surprised. Did you ask him how much it was? Answer. Yes, sir. Question. When did you ask him how much it was? Answer. When he took the money and placed it on the dresser. Question. Were you right by the dresser at the time? Answer. Yes, sir. Question. In a position to put your hand on it and count it? Answer. Yes, sir. Question. It was free there, was it not? Answer. Yes, sir. Question. But before you touched it, you asked him how much it was? Answer. Yes, sir. Question. Did he tell you how much it was? Answer. Yes, sir. Question. Did he say anything else? Answer. No, sir. Question. Did you reach for the money? Answer. Yes, sir, and counted it. Question. What did you then do with it? Answer. Put it in my pocket. Bearing in mind that the authorities are to the effect that where the offense originated in the mind of a government agent or officer and would not otherwise have been committed, entrapment is a defense to the accused. The court was asked to charge, even if you believe beyond a reasonable doubt that the defendant paid the money to the government inspector to induce him to alter his report of his investigation. By omitting the inspector's own list and substituting the defendant's list, still, if you are satisfied that the suggestion originated with the inspector and was first made by him, and that the defendant would not otherwise have done it, the defendant may not be convicted and the verdict must be not guilty. And if you have a reasonable doubt as to whether the suggestion of a payment of a bribe originated with the defendant or with the inspector, your verdict must be not guilty. The elicitation from the inspector of the suggestion that he had said something about the New York hotel where he was stopping being very expensive may have been the means of creating a doubt in the minds of some of the jurors as to whether or not the idea originated with the inspector or the defendant. If an examination of the law had not been made prior to the trial, that jury charge might not have been made, and the cross-examination along that line might not have been pursued. Perhaps a much more striking illustration of the necessity for having in mind the law applicable to the particular subject matter of cross-examination is another recent case in the New York Supreme Court. The plaintiff brought suit against the defendant to recover an amount paid by the plaintiff for certificates of stock, which the plaintiff alleged he purchased from the defendant, and as part of the inducement for the purchase, the defendant promised to repurchase upon the demand of the plaintiff. The plaintiff alleged that he had tendered the stock to the defendant and had asked the defendant to repurchase it and pay him the amount that had been paid therefor. Such an agreement is not within the statute of frauds, the authorities holding that the agreement to repurchase is part of the original contract of sale and hence constitutes an original obligation, no writing being required to evidence the obligation. The amount sued for was a large amount. If the stock, in fact, was not purchased from the defendant, but was treasury stock purchased from a corporation which was organized by the defendant and which the defendant did urge people to buy, and the defendant then made a promise that he would purchase the stock from the plaintiff at any time upon the plaintiff's demand, at the price which the plaintiff paid for it, Then the contract of purchase on the part of the defendant from the plaintiff was a contract for the purchase and sale of goods or choses in action of the value of $50 or upwards, and is not enforceable unless the buyer shall accept part of the goods or choses in action so contracted for, and actually receive the same, or give something in earnest to bind the contract, or unless some note or memorandum of the contract or sale be signed by the party to be charged or his agent in that behalf. That is the statute of frauds. The plaintiff in this case took the stand and testified, as alleged in the complaint, that he bought the stock from the defendant, paid by check to the order of the defendant, and that the defendant made the promise to repurchase. Fortunately, the plaintiff was not well informed on the law. His attention apparently had not been called to the decisions in Morse v. Douglas and Gainsbourg v. Backrake. So on cross-examination, the plaintiff testified that he was told by the defendant that this was a new corporation that was about to be organized, that the defendant said that he would be an important member of the executive force of the corporation, that his brother would be a very important member in the administrative force of the corporation, and that he, the plaintiff, was going to be let in on the ground floor, that the defendant thought the plaintiff would make a great deal of money on the purchase of the stock. A very important admission that the plaintiff made was that the defendant had said to him that he would notify the plaintiff when the corporation would be ready to receive subscriptions for the stock, and he, the plaintiff, expected to get treasury stock, and that he actually received treasury stock, and that when the defendant asked him to sign a subscription, he did sign one, and when the stock was delivered, he signed a receipt acknowledging that he received it from the corporation. He also testified that the defendant had told him that he expected that the corporation was going to do a very profitable business, and that everybody concerned in it would make a great deal of money on that stock, and that he knew that the corporation had started to do business. He admitted that on account of the purchase contract which he alleged with the defendant had made no part payment, had not accepted delivery of any part of the stock, and that there was no memorandum signed by the defendant in which he had agreed to purchase the stock, nor by his agent in that behalf. After the plaintiff had put a considerable number of witnesses on the stand, all of whom testified to the oral agreement made by the defendant, the plaintiff rested. And on the defendant's motion, the complaint was dismissed because it fell within the statute of frauds. So folks, some of these sentences are like 15 lines long, like giant paragraphs, and the law is not being explained very well. What the author is arguing here is that there was an oral contract between these parties. And an oral contract can be as binding as a written contract. A written contract is not always required. But in this case, a written contract is required if the stocks that were purchased not from an individual person, but from a corporation. Now here, the two parties had a oral agreement that if the purchased stocks could be repurchased, sold back at the same price they were paid for. So it was a zero risk transaction for the buyer of the stock. If the stock went down in value, he was supposed to be able to sell them back to the other party at the same price he paid for it. Couldn't lose money. Now, if he had purchased the stocks from a private individual, that oral contract would be binding and the other party would be obliged to buy the stocks back at the purchase price. But because on cross-examination, he conceded that he actually bought the stocks from the corporation, stocks bought from a corporation, that has to be, that agreement and the details of it, like this buyback provision, have to be in writing. And there was no writing. So apparently, this plaintiff didn't understand the law, didn't understand that if he conceded it was purchased from a corporation rather than from an individual, he would need a written agreement to be enforceable. So when he made that concession, said, I bought them from the corporation and I don't have a written agreement, that was the end of the case. Without a written agreement, there was nothing enforceable about the agreement. The only lesson to be deduced from this, and any number of illustrations that may be added, is that the law applicable to the situation which it is proposed to develop on cross-examination should be thoroughly known to the person who is trying the case, to the end that there may be developed, as the result of cross-examination, a legal bar to recovery by the side that is being cross-examined. It is to be emphasized that in these instances, the cross-examination is not at all conducted for the purpose of impeaching the veracity or integrity of the witness, nor is it to show the improbability or impossibility of the story told. The certainty exists that many cases have resulted in recovery where in cross-examination a bar to the right of recovery might readily have been created if the examiner had been apprised of the law applicable to the situation when confronting him. All right, folks, that's the end of Chapter 11, Dangers That Confront a Cross-Examiner, a guest chapter written by one Max D. Stour in the book, The Art of Cross-Examination, that's generally authored by Francis Wellman. Now, in a break from prior practice, I'm going to go right ahead and read the next chapter as well. The final chapter we'll be covering in this reading of The Art of Cross-Examination by Francis Wellman, Chapter 12, Some Comments on the Uses and Abuses of Cross-Examination. This is a guest chapter written by Emery Buckner. I'm going to read it right now here, putting two chapters in one show because this Chapter 12 is only a couple of pages long. This, in fact, brings us roughly to the midpoint of the book, as you can see here. But the whole second half of the book is not really substantive instruction on cross-examination, the art of cross-examination. It's a collection of famous cross-examiners and their methods, and a lot of it is this kind of complicated Q&A format that's frankly difficult to read well in audible form from a book, and I imagine difficult for all of you to follow along. So I'm going to wrap up our reading of The Art of Cross-Examination with this final substantive chapter in the book, Chapter 12, on the Uses and Abuses of Cross-Examination by Emery Buckner. More cross-examinations are suicidal than homicidal. There are two reasons for this: a mistaken conception as to the function of cross-examination and faulty technique. The purpose of cross-examination should be to catch truth, ever an elusive fugitive. If the testimony of a witness is wholly false, cross-examination is the first step towards its destruction. If the testimony of a witness is partly true and partly false, cross-examination is the first step in an effort to destroy that which is false. One should willingly accept that which he believes to be true, whether or not it damages his case. If the testimony of a witness is false only in the sense that it exaggerates, distorts, garbles, or creates a wrong sense of proportion, then the function of cross-examination is to whittle down the story to its proper size and its proper relation to other facts. A composite photograph of a man's face with its ears 10 times enlarged is not a true photograph of the man. If the cross-examiner believes the story told to be true and not exaggerated, and if the story changes counsel's appraisal of his client's case, then what is indicated is not a vigorous cross-examination, but a negotiation. If the cross-examiner believes the story told to be true and not exaggerated, and if the story changes counsel's appraisal of his client's case, then what is indicated is not a vigorous cross-examination, but a negotiation for adjustment during the luncheon hour. If this fails, counsel should accept the story and get his settlement by the judgment of the court or verdict of the jury. No client is entitled to have his lawyer score a triumph by superior wits over a witness who the lawyer believes is telling the truth. Lawyers can do more for the improvement of the administration of justice in their daily practice than by serving on committees or making speeches of bar associations, however helpful that may be. As to technique, the worst cross-examiners belong to the major school. They take careful notes of the witness's testimony, thus dividing their attention and sacrificing careful listening and study of the character and personality of the witness. When they rise, they begin at the beginning and stoutly march through to the end. The court or jury always listens more attentively to cross-examination than direct examination. The direct examiner frequently puts too much of himself and too little of the witness in the direct testimony. Cross-examination is a combat and therefore always interesting. The lawyer who begins at the beginning and shouts his way to the end generally achieves the result of underscoring the important parts of the testimony, thus emphasizing by repetition the damage he may have suffered. He is a macabre, always hoping that something will turn up. Sometimes, though rarely, it does. A deliberately and wisely enforced repetition of the whole story from beginning to end sometimes is indicated to bring out the phonograph record quality of a coached witness. A cross-examiner should limit himself to the vital points of the story he is seeking to discredit or to reduce to its proper proportions. A witness makes an unimportant error. The train he took, the floor on which he got off, the route he drove in his car. The truth, if developed, will neither help nor hurt either side. Time is consumed, the evidence marshaled, the admission of error finally, triumphantly wrung from the witness, all to no purpose. In the meantime, the cross-examiner has lost momentum. The high spots of his case are forgotten. In cross-examination, as well as in direct examination, opening and summation, the best advocate is he who never leaves the turnpike of his case, who is never lured into attractive country roads, who never stops to buy frankfurters or cider on the way. The motif of the case, whether plaintiffs or defendants, must ever recur. Cross-examination can frequently be skillfully and legitimately used as a sounding board for the plaintiff's case or the defendant's defense. Except where the circumstances make it wholly natural, there should be no place in cross-examination for indignation, shouting, belligerent hostility. A kindly voice and courtesy dig a better trap than high blood pressure. A jury regards the combat as unequal because of the skill and experience of the lawyer. Their sympathies are naturally with the underdog. They do not like to see him shouted at and browbeaten. Generally speaking, the adroit cross-examiner will endeavor to have the witness destroy himself and waive his personal triumph, keeping his cooperation in the destruction well in the background. In many cases, there is a fruitful field for preparation of cross-examination. Every letter or other document the anticipated witness may have signed, which has a bearing upon the case, should be secured, if possible, and carefully studied. The life history of every expected witness should be ascertained, if possible. Diligent search should be made for conversations about the case in which the witness may have indulged. Many cases are won solely by cross-examination prepared in advance. Notwithstanding this fact, immediate improvisation is what is most frequently needed. When the cross-examiner rises and does not know exactly what to ask or where to begin, he should say, "No cross-examination." And that was Chapter 12 of The Art of Cross-Examination, guest written by Emery R. Buckner. And that, folks, concludes our reading of The Art of Cross-Examination by Francis Wellman. As I caution at the start of each show, the book was written 120 years ago. The language is a bit stilted. The writing quality, perhaps, I was going to say not the best, but maybe at the time it was 120 years ago. Here it comes across as in our internet, social media, audiobook, modern society, it comes across as a bit stilted, as I've cautioned. But nevertheless, I hope you've gained some value from this reading of The Art of Cross-Examination. Until next time, I remain Attorney Andrew Branca for Law Self-Defense. Stay safe. If you've ever wondered what it would be like to have a lawyer-like understanding of the many high-profile trials and legal issues we cover, well, I've got exciting news. Our very own American Law courses offer a wide variety of law school-level courses, including the foundational courses all lawyers take in their first year of law school at a fraction of the cost and time of law school and without the toxic political environment that so pervades law schools today. At American Law Courses, we simply teach traditional American law in the traditional American way to help Americans become the best informed, most capable citizens they can be. We have a broad curriculum of courses, including criminal law, criminal procedure, evidence, property, constitutional law, and more. All courses are taught on a semester basis, roughly one live-streamed class a week for 14 weeks with an optional final exam for certification at the end. Every class is taught by a genuine legal expert in the respective subject, and because the classes are live streamed, there's plenty of opportunity for real-time interaction and Q&A with the professor. If you can't make a particular class for some reason, no worries. Every class is also made available as a recorded playback, and you have access to that recording for a full year. We've technically just ended the pre-registration period for the spring 2023 semester, which starts the second week of January. But for those of you accessing these readings of The Art of Cross-Examination, we've decided to extend that period for a few more days. This matters because during pre-registration, you can save 50% on any and all American law courses. That's a savings of over $1,000 a course. So if you'd like to learn more, now would be the time to do so. Learn more about our American law courses, access the syllabus for each course, view interviews with our professors, and much more by simply pointing your browser to AmericanLawCourses.com today.